All right, let's talk about number 3, uncoordinated beneficiaries and children as joint owners of your assets. I really enjoy that title. It doesn't mean that your kids are uncoordinated. It means instead that some of your assets aren't aligning with what your intentions are as set forth in your will. You may or may not know this. Not all assets pass under your will. In fact, some of your biggest assets do not pass under your will. Assets will pass by way of beneficiary designation, pay on death direction, transfer on death direction, or joint ownership. So your will only captures what we call probate assets, that being assets that don't otherwise say where they go when you die. And, it's not uncommon that people simply don't understand this. And it's a pretty basic concept. But if you're not an estate planning and elder law attorney, how would you know that? Or if you're not a financial advisor, how would you know that? So we want to make sure that all of your assets are coordinated to go where you want them to go. So let's say that your situation is that you have a simpler estate. And let's say that, you're single and you have one child who is perfectly healthy and capable and all that, and you simply want your assets to go to that one child. We likely will say, you know what, we're always going to prepare a will for you with protections in it that say everything goes to your one child, but we are going to set up your estate plan to avoid anything going under your will. The will is just the backup. So how we would do that is we would say, do a transfer on death deed on your house. We'll record a transfer on death deed automatically on your death. That deed means the house goes to the child. Do the same thing with your bank accounts. Pay on death, transfer on death, or your IRA, your retirement, your life insurance. All of those things can go by way of beneficiary designation, which means they pay on death to whomever you desire they pay to. Sometimes people try to do a little bit on their own, or maybe they've listened to the bank teller and they went into the bank and said, on my death, everything's going to go to my adult child here. And the bank teller might say, oh, well, then let's set everything up as joint tenants with right of survivorship, because on the death of the first person, then the survivor, the last person standing, gets all the assets. And that's how it works. Sounds like an easy estate plan, right? Maybe, but it's a bad estate plan. I'll tell you why. Even though your child is responsible, they could get in a car accident where they've caused the accident and the person who is injured comes after them. And if their insurance isn't adequate, their liability insurance, then they will go after all assets in your child's name, which includes your bank account. Your bank account is vulnerable to creditors' claims. Don't put your kid as a joint owner on any account of any size. When I say vulnerable to creditors, even though your kid is happily married, there could be a divorce. And the assets in that account, there'll be a fight over them as to, do they belong to the kid or not? Technically, no, they don't belong, but still there's going to be a fight over that. So we're trying to do an estate plan to protect against all of these arguments and threats and disputes. So having your child as a joint owner of any asset typically is a bad idea. Not just your bank accounts, but having them jointly on your house usually is a bad idea. I'll never say always and ever, say usually. Get a good attorney to look at your estate plan and say whether it's a good idea to have your child, for example, as a joint owner on a house. It depends. Let's say your situation is that you have 2 kids and you want the house to go to just the one child and the bank accounts, et cetera, to be divided between the 2 children. And we're still going to avoid probate because we can do so. We still will want your will as a backup to what your plans are to say that my house goes to the one child that you want to receive it. Even though it's not going through your will, it's going by way of transfer on death deed. The reason we want that is we want a backup to clearly show that is what you wanted. That helps avert any dispute in the future between the two children and the one who says, no, mom wanted everything to be split equally. You are the one that convinced her to give you the house. If we have the will backing it up and the lawyers who drafted the will standing behind it to say, no, mom's intentions clearly were that the house goes to this one child, it shuts down any disputes, any will contests. So you're trying to make sure that you take actions to protect your plan from attack. So we want clarity, we want to avoid confusion. To the extent possible, we want to avoid hurt feelings and litigation, though that's not always possible, but we can take steps to mitigate those risks. So we've talked about beneficiary designations. Let me circle back to what we had talked about earlier about life changes. Let's say you have a divorce, you've been divorced. Do make sure you take a look at your 401k, your employer sponsored retirement account, because if you don't change it from your ex-spouse, they get it. And that's probably not what you want if you have divorced that person. Maybe it is, but likely it is not.